is not possible to frustrate.
Now, I do have a question. One of the things that's really concerned me the last couple of years, I've always considered Cheryl Allen a moderate. And there were some things that occurred that she and some others, I can't even think of who else it was, tried to get something done and tried to get an ethics thing going, something looking at some of the behavior. And it seemed like it just got really kind of ugly and everything. And I've been really concerned about that because it just seemed like it wasn't a bad thing to do. And so will this help mitigate that type of thing? Will it sets up a process, it's a legal process. And
well, there are a lot of good people who serve in the legislature.
Well, there are, most.
And there are a lot of good legislators who, over the years, have tried to propose various measures to strengthen the ethical procedures that legislators are expected to follow. For a lot of different reasons, most of those have not gone anywhere. And as I said, there are a lot of reasons that happens. Let me just share with you a conversation I had last spring with a prominent lobbyist in the state who, looking back on the events of the previous year, said, there will never be substantial ethics reform in this state until the citizens of the state, by initiative, require it to occur. There are a lot of people who have different opinions about this. There are a lot of people who bring to that experience certain expectations, and people have a hard time on occasion voting against what they perceive as something that they're entitled to. We had a Secretary of State several years ago who many of you would know if I shared his name with you. And he said when he was elected to office, in the first year that he took office, one day there was an envelope in the mail, and he opened it up, and it was an invitation from one of the ski resorts in Utah for him and his wife to spend a week as guests of the resort and enjoy a ski weekend. And he said, we had one of the nicest weekends you can imagine. And then the next year, the invitation didn't arrive when he expected it to. And he said, I thought about that, and I thought maybe I'd better have my secretary call and just ask whether they forgot to put this in the mail. And he said, no, on second thought, when I began to think about it more, it dawned on me that I had become, in my own mind, entitled to an opportunity to enjoy a weekend on someone else's dime. And I just thought about that more and decided that wasn't appropriate for me as the Secretary of State to be doing. And I didn't ever do it again. I thought that was a pretty interesting story, and it's to his credit. But there are a lot of reasons why the legislature hasn't acted. A lot of people would like action to occur, but it just has not occurred. So we're bringing this initiative as a way of making certain that it does.
Other questions? Another one, Michael?
Still unclear on something. Now, in the beginning, you showed us a slide. Recently, a legislator was accused of something, and you said they appointed 4 Democrats and 4 Republicans in the committee to examine the complaint. Now, is this still going to be the end process once this commission finds accuses somebody of?
So you want to know what's going to be different?
Is that going to change at all, or is that still going to be the way things ultimately end up?
Okay.
Under the bill, when the commission forwards its recommendations to the Speaker or the President of the Senate, then the legislative house involved has to make a decision whether it's going to accept those recommendations or whether it isn't. And all of the deliberations about accepting or rejecting are public. They have to take a public vote. They can vote it up or down. Once they do that, they can do whatever they choose or do not choose to do, and that's the end of the matter. But the significant thing, in our view, is that there will have been a transparent hearing over this issue of an alleged violation by a fair and impartial panel. And its findings will have been made public. And from there, it's up to the legislature what happens next.
So then it's not a 4-4.
Sharon, state your name,
I'm
please.
sorry, Sharon Ott. I'm just a citizen
Living.
in Washington.
Thank you.
So it doesn't go to the 4-4, it goes to a body?
I didn't understand.
Well, one of his things, and I feel the same way, from the beginning, it was like, it has gone to a committee. If there was an issue, it went to a committee of 4-4, 4 Republicans, 4 Democrats. Would it now go to the same 4-4, or does it go to a body?
No. If there is an ethics complaint filed, it is reviewed by the executive director of the commission. If a determination is made that there's some reasonable basis for this complaint to be treated as a formal disciplinary hearing, then the commission makes that decision to take it to the next level. Or if it determines that this is a frivolous complaint, then it dismisses. But the commission process we're establishing doesn't deal with a 4-4 committee of the legislature.
Okay.
Just a question on that process. Evan Vickers, Cedar City again. I know that there's provisions in the initiative that we can't, for example, if I was accused of something and I was brought before the commission and I needed an attorney present, I would not be able to use the legal counsel of the House. I would have to go hire a private attorney, and then it would be a responsibility of the state or the citizens to pay my bill. Is that the way you understand it? And I was just wondering why that provision, why not be able to use, why wouldn't the judicial council from the House or the Senate have at least say, yeah, we'll represent it, no, we won't?
That's an excellent question, and I'm happy that you asked it. We've provided specifically that the Legislative General Counsel may not represent legislators in this process. And then we've provided also that they may select whatever attorney they choose, and the costs of that representation would be financed out of the public treasury. The reason we did that is because, in our view, the Office of the Legislative General Counsel, as it has been established, and there's a constitutional provision which establishes it, Representative Peterson bears some responsibility for the fact that it's the way it is. But it is ethically impossible as lawyers for lawyers to represent both sides of the dispute. It's ethically impossible for lawyers not just to represent both sides of the dispute, but if they have previously represented one party, to then, even with the consent of another party, represent the other party. In our view, the Legislative General Counsel is responsible, number one, to represent the legislature. We've had a number of discussions with John Fellows, who's a fine lawyer. And in John's view, if he were here, I think he would say, I have 104 clients, 104 members of the legislature. I also represent the legislative leadership. I represent the legislature as an institution. I represent the Legislative Management Committee, and on and on and on. In our view, there is a conflict of interest where a legislator personally is accused of some unethical conduct that may involve other members of the legislature. It may involve a process that other legislators have been involved in. There is an issue of confidentiality between comments that have been made by legislators to the General Counsel in their legislative capacity. And we did not want to intrude upon that Legislative General Counsel privileged communication channel. So we felt it was most appropriate if we take this process outside the General Counsel's office and avoid the creation of yet a further conflict of interest that might occur if the Legislative General Counsel were involved with a legislator as a legal representative, if the Commission sought further assistance from the Office of Legislative